All right, welcome.
Hi.
Glad you're here.
I'm so glad to be here.
All right, so these are our legal ledger sidebars, which is something new we're trying this year, which we sit down, we talk about some hot topics, things that members are asking us on the hotline about, and just really excited to do this with you, Jenny.
I'm really glad to be here. I know we talked about this at our retreat last fall, and it was kind of a new thing. We're going to talk to each other like we, work together.
Yes. So we should have introduced ourselves. I'm Sarah Clark. This is Jennifer Harden. We're part of OSBA's legal division, and we are here to talk about executive sessions today, which is a super hot topic on our hotline. I'm always surprised by how many questions we get on this topic. And so I think you're going to kick us off with some just basic information about it.
Yeah, I think everybody knows that meetings are usually required to be held in the public by the Open Meetings Act. So the only portion of the meeting that can be behind closed doors is that portion that is the executive session. And you have to do it in compliance with the law, which means that you have to do it for one of the reasons the law allows you to do.
Yeah, and there's 7 or 8 reasons that apply to school districts. And so we've got personnel, which is one of the reasons. I know we're going to talk about that a little bit more down the road. Property matters, that you can talk about property matters behind closed doors, the purchase or sale of property. Pending an imminent court action, your attorney has to be present. I know we're going to talk about that in a second too. Collective bargaining matters, security matters, and then sort of the catch-all matters to be kept confidential by state or federal law or regulations.
Right. And when the board's ready to go into executive session, it can just say, okay, everybody vamoose.
No, not quite right. So they've got to do a motion that specifically lists one of those 7 or 8 reasons that we just talked about. You've got to have a roll call vote. So this is one of those votes that specifically requires you to actually name the names and call the roll. Majority of the quorum has to vote to go into executive session. And again, that motion has to include one of those specific statutory reasons to go into executive session. So not as easy as just declaring it so. We are in executive session, not that
Everybody
easy,
get out.
Yes.
So once about that motion,
Yes.
I think we've both seen motions that are a little questionable, like motions where somebody says any of the reasons listed, or they read the entire G1 exception, or they say personnel reasons, and neither of those is okay, right? The law specifically says you have to choose one or more of the reasons that you're actually going to be going into executive session if you're under that G1 personnel category. And I think in 2001, the Supreme Court said, Ohio Supreme Court that is, said you can't just say personnel.
Right.
That's not revealing enough.
Right. Right. So what if they wanted to go into executive session for 3 reasons? Their motion said, all 3 of those reasons, and then when they get behind closed doors, it's just one. They only talk about the one.
Yeah, there was a citizen that actually challenged a board on this very topic recently, and the Supreme Court of Ohio made a really great decision in which they said there are situations where a board may reasonably think it's going to talk about one of those things or more than one of those things, and then end up talking about fewer than it thought it would. So if your motion says, for example, discipline, dismissal, or demotion of the employee, and you end up resolving the discussion on the dismissal stage or on the discipline stage, it's still an okay motion, and the executive session isn't subject to challenge just because you didn't end up discussing all 3 of those areas.
Perfect. And I know the other question, or the other area that we get a lot of questions about is the area of minutes, and whether you're supposed to be keeping minutes in executive session, whether you're allowed to take minutes in executive session. And the Open Meetings Act says you don't have to take minutes. In some cases, you probably don't want to take those minutes because they could be subject to public records requests down the road or discovery. But boards are not required to take minutes. The minutes just need to reflect sort of the general subject matter, the reason you're going into executive session in the first place. Again, that can be the listing of the statutory reason to go into executive session. And you don't have to prove what was discussed in executive session. I know you just mentioned a Supreme Court case. There was another Supreme Court case recently that talked about this presumption of regularity, and it presumes that you went into discussions in executive session that were appropriate, and they're going to presume that you complied with the law unless there's evidence to the contrary. So good news for our school districts.
While we're talking about that, sometimes when people talk, they start talking about other stuff.
Yeah.
What happens when the board goes rogue and starts talking about things they're not supposed to, that weren't mentioned in the motion?
And that happens, just a normal conversation, right? So when that happens, you've got 3 potential options that you could do. You could either get back on topic and stick to the discussion that on the topic that you went into executive session to discuss. you can go back into open session and have the conversation about whatever topic it was that, you know, came up during executive session. So have that portion of the conversation in open session. Or if it's a topic that is an appropriate executive session topic, but not one that was in your initial motion, just go back into open session, make a new motion to go back into executive session for that second topic, and then have the discussion back in executive session. So totally appropriate.
While we're talking about going back into open session, one of the questions we sometimes get is, how do we do that if we're not supposed to vote in executive session, which is true.
Right.
Board members can't vote in executive session. So the way to do that is the president just says, we're back on the record, or we're back in open session, or in cases where your board actually leaves the room, you go back into the room.
Physically get up and walk over and
Right.
do it, maybe an empty room. But yeah, yes, it's an important distinction to do. So
And then the minutes don't reflect that you made a motion or had a vote. They just say,
back on the record.
back on the record at this time.
Yep. And
Got it.
so how do you decide, or who gets to decide who comes into executive session? I know it's common for superintendent and treasurer to be there, but who gets to decide that?
It's in the board's discretion. There are two situations where they don't have a lot of discretion. The first is that all 5 or all 7 or all of the official members of the board are, of course, entitled to be in the executive session. You can't just block someone because you're not really interested in what that person has to say. The only time that isn't the case is if one of the board members has an actual legal conflict of interest, and because of that conflict, the law says he or she shouldn't be participating in the discussion. So that's one situation where the board member wouldn't be there. And then for anyone else, the only time the law absolutely says you have to have X person in the room is when you're relying on that reason to go into executive session that is consultation with your attorney. You can't go into that executive session to consult with your attorney unless the attorney's actually there.
True. And so we also had talked about the fact that at the end of the executive session, you need to either close the meeting or physically, go back to the space where you had opened the meeting. That's also true to adjourn the meeting of the board, right? So we have boards that I think that they can just adjourn the meeting from executive session. And of course, that's not the case. They actually need to return to open session to adjourn the meeting. So don't end that meeting while you're in executive session. And then speaking of adjourning, Jenny, I think we're at the end
Are we
of
done?
our very first sidebar.
Oh,
so
my goodness.
we'll have one of these every 6 weeks around-ish, right?
Yeah, I
So
think that's the plan.
I hope people will tune back in. And then Jenny, I don't know if you have any final thoughts.
Just,
before we wrap up?
I want to welcome people to send their ideas for future topics if they have one. We are open to your suggestions, and as our fan base grows, we're sure we'll get them.
Dozens of people are watching today.